Respected members of my latest judgment group, I am having a topic regarding guidelines issued by Honorable Supreme Court to High Courts on summoning of government officials. It says personal presence should be exceptional. So, going in detail through this guidelines to address the issue of arbitrary and frequent summoning of government officials by the courts, the Honorable Supreme Court on Wednesday, 2nd January 2024, issued guidelines to the High Courts. The bench comprising Honorable Chief Justice of India, D.Y. Chandrachud, and Justice J.B. Pardiwala and Justice Manoj Mishra framed a standard operating procedure, shortly SOP, on summoning of government officials and directed that all high courts should follow it. All high courts should consider framing rules to regulate the appearance of officials after taking into account the SOP. Now, highlighting SOP point-wise, the first point is personal presence may be required in evidence-based adjudication, summary proceedings, and non-adversarial proceedings, where the court requires assistance on complex policy issues. Other than these cases, if the issues can be addressed through affidavits and other documents, personal appearance may not be necessary and should not be directed as a routine measure. Second is the presence of government official may be directed in cases where the court is prima facie satisfied that specific information is not being provided or is intentionally withheld, or if the correct position is suppressed or misrepresented. Third one is the court should not direct the presence of official solely because the stand of the official in the affidavit differs from the court's view. In such cases, if the matter can be resolved through existing courts, the issue be decided on merit accordingly. And fourth one is in exceptional cases where the in-person appearance of the official is called for by the court should allow as a first option the officer to appear before it through video conferencing. And fifth one is the invitational link for VC appearance must be sent by the registry of the court to the given mobile number and email ID of the concerned official by SMS, WhatsApp, email at least one day before the scheduled hearing. And when the personal presence of the officially directed, the reason should be recorded as to why such presence is required. Due notice in person. Due notice for in-person appearance giving reason must be served in advance to the official, enabling the official to come prepared. The court should, to the extent possible, designate a specific time slot for addressing matters where the personal presence of an official or a party is mandated. The government officials who participate in the proceedings need not stand throughout the hearing. Standing should be required only when the official is making statements or responding to the court. During the course of the hearing, oral remarks which have the potential to humiliate the official should be avoided. The court should refrain from commenting on the physical appearance, educational background, or the social standing of the official appearing before it. The courts must cultivate an environment of respect and professionalism. Comments on the dress of the official appearing should be avoided unless there is a violation of the specified dress code applicable to their office. courts must consider the complexities of the decision-making before specifying timelines for compliance of order. A reasonable time frame must be accommodated. If an order is passed and the government seeks a revision of the specified time frame, the court may entertain such request and devise a reasonable time frame for the compliance of judicial orders. The court should exercise caution and restraint while initiating contempt proceeding. In a proceeding issued for contempt for willful disobedience of order, the court should ordinarily issue a notice to the alleged contemner seeking an explanation for action instead of immediately seeking personal appearance. Following the issuance of notice, the court should carefully consider the response of the alleged contemner and should decide the future course of action. If the original order lacks a specific timeline, the court should consider granting an extension. If the order specifies a compliance deadline and difficulties arise, the court should permit the contemner to submit an application for extension. So the court passed the directions while setting aside the directions issued by the Honorable Allahabad High Court to take into custody two secretaries of the UP government for alleged non-compliance of directions regarding the facility to retired judges. You might be known, last year the Supreme Court had stayed the High Court order which took into custody the Special Secretary Finance and Secretary Finance of the UP government over the non-compliance of directions to provide domestic help and other facilities for retired judges and directed their immediate release. During the course of hearing, the Solicitor General of India, Tushar Mehta, requested the Chief Justice of India to lay down guidelines on summoning government officials and submitted a draft SOP. The Chief Justice of India agreed to frame the SOP. The draft SOP, among other things, suggested that before initiating contempt proceeding, the plea for review on behalf of the government must be considered by higher courts. If it is pointed out that certain points of law were not considered during adjudication. Now, from where I have taken this data is the case title is State of Uttar Pradesh versus Association of Retired Supreme Court and High Court Judges, Special Leave Petition Civil, Diary number 16613 of 2023. That's all. God bless you all. Thank you for watching.